Wonderful. Well, I think we're all present. I want to welcome everyone who's attending this roundtable. I am Mortimer Sellers, Regents Professor of the University System of Maryland, but more important, Chair of the ABILA Committee on the Legitimacy and Fundamental Principles of International Law. And this will be a roundtable on reinvesting in the legitimacy and fundamental principles of customary international law. And the roundtable is a co-production of the Legitimacy Committee and the ABILA Committee on Customary International Law, chaired by Brian Leppard, who I think is present watching us. So this is a roundtable, not a panel. Roundtable, which signifies conviviality, equality, and agility of discourse. So my hope is to give you a conversation rather than a lecture. A conversation among wonderful and inspiring experts, but a conversation nonetheless, to which you all, by which I mean our audience, can participate, I hope, or think, by asking things in the chat or saying things in the chat. And I'm going to attempt to look at the chat and then artfully incorporate what comes up in the chat into our conversation, if I can. So we want the audience to feel themselves a part of this, although actually we can't see you and you can't see each other. And the questions that I'm going to begin with are the questions with which we're going to, the fundamental questions, perhaps, well, at least the ones that will launch our discourse. Are there, in fact, any fundamental principles in customary international law? If so, what are they? And is customary international law legitimate at all, in the sense that we owe it deference, respect, perhaps obedience? Is it legitimate in any meaningful sense at all? But first, I want to introduce the participants to the roundtable. Dr. Noura Arayawi is Associate for Research Ethics at the Hertie School in Berlin and a postdoctoral researcher at the Centre d'Histoire et d'Anthropologie du Droit at the Université Paris-Nanterre. She's published a book on the changing nature of customary international law. I think she has more books in the pipeline about customary international law, and we're very pleased to have her as one of our participants. Jean d'Aspremont, Professor Jean d'Aspremont, is Professor of Public International Law at the University of Manchester and at Sciences Po Law School. And he too has recently published a book, one of many, but recently The Discourse of Customary International Law, published by Oxford University Press. Amri Sender, Dr. Amri Sender, acts as counsel to states in various dispute settlement proceedings before the International Court of Justice. He advises states, international organizations on all aspects of public international law. But for our purposes, perhaps most exciting, from 2012 to 2018, he served as assistant to the International Law Commission's special rapporteur on identification of customary international law. That was Sir Michael Wood, with whom he worked very closely. And so, so very useful set of qualifications. And then Professor Ingrid Brunk-Wirth is Associate Dean for Research, which is to say they must love her research very much to make her in charge of the whole school's research. She's also Heron Strong Curry Chair in International Law, and she is Director of the Cecil D. Brandstetter Litigation and Dispute Resolution Program at Vanderbilt Law School. So we've gathered a very strong and interesting group who I believe and indeed hope do not completely agree with each other about everything. We'll soon discover that. And I think what I'll begin by doing is just very briefly asking more or less the same question to everybody, just to get things started. And then, you know, as we begin to speak, we'll begin to discover what's worth talking about. And I think I'm going to address our participants in reverse alphabetical order by first name, so which may become confusing for me. But anyway, the first one is Professor Amri Sender. So Dr. Sender, could you please answer my initial question, which is, are there any fundamental principles behind customary international law? Is there any kind of coherent principle behind it? And if there are such principles, give us some thought as to what they might be.
Thank you, Tim, for this very kind introduction, and also for the privilege of sharing this so-called stage with real experts in the field, and to discuss a topic that international lawyers seem never to be too tired talking about, which is customary international law. And I would like to make two brief points. One of them is really related to your other question as to whether states actually treat customary international law as anything more than advisory, or as anything binding and legitimate. And I would say I disagree with the suggestion that they would treat customary international law as only advisory. States might definitely break rules of customary international law. They will deny they exist, or they will deny they apply in the circumstances of a particular case. But I do not think they deny that customary international law as such exists. And I will remind us, of course, that virtually all states of the world are party to the ICJ statute that very safely secures the place of customary international law as a source of international law that is relevant to the conduct of states. And I think it's worth recalling that this legitimacy crisis is one that has been with us for a long, long time and has taken various forms. I mean, we had the codification movement at the beginning of the 19th century that sought to do away with all customary rules. They were too uncertain, too incomplete, and they wanted treaties and codes to replace all of them for international law's sake. Then we had the Soviet jurists that came and sought to undermine the international legal order and say customary international law are backwards looking, they're the capitalist and imperialist code for trying to be imposed on weaker states, and they were soon joined, of course, by lawyers from the developing world. All that has died out. Of course, a passionate attack came from the academics who thought customary international law was a myth or was just not good enough as a modern source of international law because it was too slow, because it was unjust, undemocratic, and so on. But customary international law really survived all of these attacks and withstood the test of time. And what I would like to very quickly highlight is three reasons why the legitimacy of any particular rule may be in danger. And that has to do only, I think, with the integrity of method that one employs to discover and to set out what that rule is. And of course, we know that century-old formula, a general practice accepted as law. And I think it is when we try to bypass this requirement that states keep pledging their allegiance to, most recently in no uncertain terms, during the work of the International Law Commission on Identification of Customary International Law, that we run into trouble. And I'll just very quickly say three reasons why it's important that we abide by this formula and abide by this method, by this integrative method. One is that it is crucial for the authority of international law that we maintain a distinction between law and proposal. If we cannot say what law is and law is not, then we lose the confidence of the states we wish the law to keep in check. Secondly, and I think it was Professor Bin Cheng who said that pseudo-law is the worst enemy of the rule of law. We have an expert on the rule of law, Nora, here, but I'll stop at that. Secondly, a determination that seeks to limit the sovereignty that states love so much must be realistic in its application. It must be dispassionate, all about reality. Otherwise, states will just ignore it when push comes to shove and they need to decide whether to comply with it or not. My final point is that I think it was Michael Reisman who reminded us that the determination of customary international law has a moral element to it as well. And he said that just as it would be profoundly immoral and intellectually dishonest to try and bind a state to a treaty rule that it had never agreed to, it would be profoundly immoral and intellectually dishonest to make up a customary rule that doesn't exist and try and bind the state in that way. So I think if we have any threat to the legitimacy of international custom, it would come from that direction.
Thank you very much, Dr. Sender. And I now call on Dr. Nora Arayarvi to either to say whatever you want about what he said, or to say about whatever you want, in fact, about anything.
That's a lot of freedom of choice. Thank you, Tim. And thank you, Omri. I think that was a great, insightful introduction to what we are talking about today. I've been thinking lately quite a lot about change, and not even lately, for quite some time, the process of change in customary international law, and what are the features there and how that may impact the legitimacy of customary international law. And there, I would like to point out three things. So the first, actually, one of the central problems in the process of change is the same that we deal with when we are looking at the identification and formation and construction and discovery and even interpretation. There is a lot of conceptual confusion there. And I know Jean has written and spoken quite a lot about these confusions, and also the idea, like, do we have this one set point, the specific point in time of custom making, which I agree with Jean that there is no such point. We are dealing with a living instrument, if you like, that is undergoing a constant development, at least in theory. The second point regarding change is the idea that in order to change custom, you would need to violate the existing customary rules. And here I think theory and reality do not really match. This leads to the third point, which is the chronological paradox. Having to believe that practice is required by law before it is law in order to form custom or to change it. And I think that is highly challenging to claims of legitimacy. Now, here, I think it's foolish to think that states would actually believe that the contradictory practice they engage in is required by law when it is not. Even at the best of times, this seems unlikely and illusional conceptualization that states would be sort of dum-dums doing this and then saying, oh, we thought it's required by law when it is not. So I have been trying to carve out a little bit something that relates more to the opinio juris side of it. So looking at the reactions and responses to possible non-compliant practice as the opinio element, as opposed to that actual belief that the act is required by the law. And I think here, looking at the responses of other states is really crucial. And there, the practical and normative persuasiveness of these communications or correspondence among states plays a crucial role. So I would say, even as a positivist, I think we need to rethink at least some aspects of traditional sources doctrine and to move towards more pluralistic and diverse understanding, what is inclusive. And this comes into play in this idea that communications play a crucial role, and that means communications of all states, possibly other actors. And I think there we are looking at something quite interesting if we can conceptualize this sort of shift in how custom changes and possibly how custom forms, and reinvesting the legitimacy into customary process through these communicative means. I would have more to say also on this idea that there is a necessity to violate a rule in order to change it, but I think for the sake of time, that's maybe something we can come back to.
Thank you very much, Dr. Arayarvi. And Now I call on Professor Jean d'Espermont.
Thank you, Tim, and thank you, everyone. It's a pleasure to be here, and I'm of course pleased to be here with very distinguished colleagues and dear friends with whom I had the. Well, probably the audience may be wondering what is there to be said. I must say that the way Tim has put the question is actually very novel. And just that shows that there is still a lot to be debated and explored. I mean, I like Tim's question, which is, are there fundamental principles of customary international law? I think the question is very, very provocative because it seems to allude to a hierarchy or a differentiation between different principles of customary international law, some of which would be fundamental and some others which wouldn't be. I must say that this question has got me very provoked. I had the intention to say many other things, but actually I want to take the question at face value and be over loyal to it. So Tim, it seems that today we're just questioning the existence of different types of customs or different types of customary principles. In that respect, and that's the main point I will make tonight, I think I wouldn't call it a hierarchy, and I wouldn't maybe distinguish between fundamental and non-fundamental principles, but I do think a distinction that is helpful in this case is a distinction. It's an old distinction. This distinction which was found in British analytical jurisprudence. It's a distinction between primary norms and secondary norms, and I think it's norms and customary secondary norms. And I'm saying this in a way which is maybe not very favorable to custom, because I do think there are, especially from the perspective of legitimacy, there are huge problems with customary secondary rules. And what I mean by secondary rules, I refer to rules on statehood, rules on sources, rules on custom, rules on interpretation, rules on responsibility. So all the rules about rules. And as we know, all courts in the world claim that these rules on interpretation, on responsibility, on sources are custom. And so these are the customary secondary rules. And I believe, I'm afraid that this is a very problematic statement. It's something we all train to say and to repeat in law school, and this is something we all repeat in our scholarship, but I do think it's a very, very wobbly statement. Because if, as Omri said, if we have to be loyal to the two-element doctrine, well, I wonder where the state practice is when it comes to rules on interpretation, rules on responsibility, rules on attribution, rules on legal personality. I think there's no state practice. There's a lot of practice. It's an argumentative practice. It's an argumentative practice which is heard in courtroom. It's judicial practice. But I don't think we have anywhere any actual behavior on the fact that the wrongful act is made of two elements. No, it's an argumentative practice. It's not a behavioral practice. I don't think that we have behavioral practice about how rules are given a content according to Article 31 of the Vienna Convention of Treaties. So I don't think there's state practice, which I think if we follow Omri's very, very important claim tonight, which raises very important question when it comes to the customary status of second rules of international law. There's also another, I believe, obstacle that regarding this claim, and it's the fact that most of these rules, these secondary rules of international law, state responsibility rules, rules on sources, rules on interpretation, they are not norm creating. There is no norm. There is no do or don't. Take 31, take 38. There is no obligation there. Obligations for states. So state cannot possibly produce practice simply because there's nothing to comply with to start with. And I think that's a criterion which is often overlooked, even if the court in the Continental Shelf case in 1969 was very clear. It even made it the first element, the norm creating character of the standard. The court said it must be in the first place necessary to see whether the equidistance is of a fundamentally norm creating character. These second rules of international law are not of a norm creating character. They do not prescribe any obligation for states. There is no obligation to abide by anything. On the how, for decades, we've all been repeating on and on that these are rules of customary character. I'm not saying that I'm here to challenge the legitimacy of customary rules, of customary secondary rules, but I'm just saying that if we want to vindicate the legitimacy of these rules, the rules on responsibility, the rules on sources, the rules on interpretation, we've better not bank on their customary character. And I think that if there is a distinction between different type of customary rules, that's where it is. It is between primary and secondary rules. And this is why I felt that Tim's question was extremely appropriate and calling for I think new reflection. Maybe one final quick point on the very question, on the other question of the panel, which is this sort of idea of legitimacy. In that respect, and to make sure we don't talk past one another, I would think that, and I would say that we need to distinguish between legitimacy as an experience and legitimacy as a discourse. I think international actors can probably experience legitimacy or illegitimacy of rules. It's an experience, but international law itself will not allow them to actually formalize that feeling and that experience. Legitimacy as an experience is not something which is within the repertoire of international law. So within international law, there's no discourse possible on legitimacy. If we want to speak about legitimacy, we have to be outside the international law discourse. And so if you want to challenge legitimacy, as some actors may want, if they experience it, they can't do it through legitimacy, because there's no such a thing as a legal category of legitimacy. They have to do it through the two-element doctrine. They have to do it through bindingness. They have to do it through interpretation. So the main point is, if we discuss legitimacy of customary rules, we can't do it from within the discourse. We have to do it from outside the discourse. If we want to do it from within the international discourse, it's going to be through the categories of law and non-law, as Omri has again referred to, or the other categories of bindingness or interpretation. So anyway, just a few thoughts to kick off the discussion, but let me say that I'm enjoying being here, and I really liked how Tim framed the question.
Thank you very much, Professor d'Aspremont. Professor Wirth.
Thank you so much. Let me add my thanks to the panel organizers and everyone else who's participated in organizing the conference. So I'm going to just throw out maybe a slightly different way of thinking about custom and see if it helps our conversation at all, whether it proves useful. Sometimes I think of custom in a sense almost as a constitutional norm, or having a constitutional sense within the international legal system. And let me explain why I say that and what that might have to do with both legitimacy and the rules around custom. So I think custom has constitutional aspects that treaties do not, both in terms of doctrine and in terms of the functions that are served. So some of this has already been mentioned. In the doctrine, custom provides for entrenchment of norms. So Nora's points notwithstanding, we generally think of custom as not permitting exit, that states have to breach the norm and seek the development of a new customary norm. States that come into existence after a customary rule has developed are bound by it, whether or not they consent. Some rules have obtained the status of jus cogens, of course, from which no derogation is permitted. So custom entrenches law in a way, in many ways, that treaties do not. And entrenchment, of course, is the core feature of constitutionalism. So people are bound by constitutions to which they didn't formally consent in many ways. And just as jus cogens norms put some norms entirely outside of the political process, that works with constitutions as well. We're putting some ideas and some forms of government conduct simply off the table constitutionally, or outside the norm of regular change. So of course, very closely related to this idea of entrenchment are the problems of both the twin problems of consent and legitimacy. Customary international law, of course, as Omri has suggested, is often said and does formally rest on the consent as states, just as constitutions formally derive their legitimacy from the consent of people. Yet, as we've already mentioned, customary international law in some ways binds states contrary to their consent. It's also formed not necessarily through the active conduct of states, but through their acquiescence to norms that are developed through the conduct of other states. Here too, constitutional theorists often argue that constitutions are successful when they coordinate behavior over time and people sort of acquiesce in an ongoing sense in that operation. In both constitutions and in customary international law, it's difficult to fully defend acquiescence as a form of consent. I mean, you can try and it sort of fits, but it doesn't actually fit very well. And that's, I think, a lot of the problem with consent and legitimacy, right? A lot of states kind of acquiesce, but do they really acquiesce? So that's entrenchment. In terms of function, some of the functions that customary international law plays, I think you think of them as in both structural and aspirational senses. So customary international law sets some minimal underlying rules for the interactions of states. In some ways, custom structures the production of other international norms, right? States are required, as we all know, to afford head of state immunity and provide immunity of diplomats, to abide by their treaty obligations, to respect national boundaries, to respect foreign embassies. Those are structural in a sense in the way that constitutions are. So like constitutions, customary international law expresses important values and aspirations. Human rights are so significant within customary international law that they form a large part of jus cogens norms. These aren't structural and they don't enhance states' interactions with each other, but they are profoundly aspirational in terms of what it is we want international law to do. Now, of course, custom is kind of different from the way we think of a lot of constitutions. It's often vague, it's unwritten usually, it's not explicitly negotiated in terms of bargaining. Of course, constitutions share these features as well too. They often leave difficult interpretive questions kind of down the road. So, I mean, if this analogy has any force, I guess one way to think about it is the international legal system itself, strong enough that we even want to have any constitutional style norms in it, or are we so divided sort of globally and collectively that we can't rely on acquiescence? We don't want to create any kind of constitutional style entrenched norms. And that might be one answer, but if we think that customary international law does perform these entrenchment or constitutional style protections, and that's important, and that we actually value that and want that, and I'm accepting that we might not, but if we do, I think that has some suggestions, some payout for some of the rules of customary international law. So I think, for example, it suggests that opinio juris and state preferences are really important to the formation of custom, but maybe state practice is not. So the constitutional value of custom isn't so much depending on past conduct, but on whether states actually wish to coordinate their behavior in the future. I realize this will be deeply controversial, as most of the things that I've said are, so I'm trying to kick off the debate. So second, and also very controversially, I wonder if changing the secondary rules of custom to make it more consent-based actually diminishes sort of the value of custom. Do we want custom to be doing something different than soft law and treaties? And I don't just mean doctrinally, how is soft law different? Do we want it to have a different function in our system? And if we do, we can try to make it more and more like treaties and so on. But then to the extent it has a constitutional function, I think it plays it potentially less successfully. And so now, hopefully I've said enough that I think everyone will disagree with, so I will stop talking.
Well, I want to thank everyone for very, very fascinating and provocative first remarks. So that's great. I think Omri said, look, it exists and don't make it up. And we have opinio juris and we have practice. And then subsequent speakers said, we're going to make it up. We don't like opinio juris, or we don't like practice. So it's all on the table now. And I actually want, and I think maybe Jean invited us to consider how fundamental, whether or not the fundamental principle actually is opinio juris and practice, or whether there is something much more fundamental that makes those valid if they are valid. So I think we've reached the point now where everyone probably has lots of things in there that they're willing and ready to say. And I think if I just call on you randomly, you'll say something. But if you're really, really excited, you can indicate in some way. I'm going to start by calling on Omri, though, because he was the first, and then he's heard a lot of things, I think, which challenge a little bit his original statement. So I wonder if you have some responses.
Thank you very much. And it was a real joy listening to all of that, and indeed a lot of food for thought. It's amazing how even new arguments come up after a discussion that has lasted centuries about customary international law, and it's fascinating to be a part of it. I want to make four very, very quick remarks, and they touch on the various points that were made here. One is that there is this forgotten paragraph in a judgment of the ICJ, a chamber of the ICJ in the Gulf of Maine case, where they were referring to different kind of categories of customary international law, fundamental, and then the rest of it seeming to suggest that fundamental didn't really need a lot of practice in opinio juris, but the more kind of mundane day-to-day interaction did. It's an interesting point, and I think there was a lot of scholarship saying that some rules are universal, meaning they're binding on everyone. Others are general, meaning they're binding on everyone apart from persistent objectors. And then there are particular rules that are more regional or local or whatever. So this notion that there are different rule categories of customary international law is out there and maybe worth going back to at some point. Secondly, the issue of a problem of finding what the rule is, of course, is not unique to customary international law. I mean, half the disputes in international law are about what does this treaty say, not what is the rule of customary international law. So the problem with law finding that may be a danger to legitimacy exists in other areas of law, also in domestic law, not just in international law. I think, Ingrid, precisely because the international community is so divided, we must rely on acquiescence as a huge force in the development and maintenance of customary international law. I mean, it's the one tool we have to kind of get everyone together under one roof with a set of rules and say, this is custom, it's binding on all of you, unless you took the real effort and resisted it or persistently objected to it at a certain point. So it's very useful precisely because of this great difference between states. Finally, I'll just say, and this goes to Nora and Jean a bit, that I think it's interesting to ask ourselves why it is that developing states really abandoned this big campaign they had against customary international law. This was a huge issue to say this is bad law imposed on us by the West, by the developed world. We want no part of it. We never agreed to it in the first place. We're new states. And this just kind of disappeared. And I think one of the reasons is that these states not only kind of maybe have grown up to like some of the rules and find them, you know, working in their favor, but believing they can change them. And I think they can influence them. So I wonder, and maybe you'll have different views, if that's one of the reasons why custom has become more legitimate and is, open to change in that way. Anyway.
Nora, do you want to respond to that? And I think that, and then Ingrid Brunkworth will also respond. But first, Nora.
Thank you. I have quite a few things I have noted down, but I'll try and limit this to a couple. So first of all, I think it was interesting that the notion of persistent objector was only mentioned for the first time by Omri just now, which is something that possibly is indeed one of the fundamental principles of customary international law. We are aware of the critique towards the persistent objector rule, whether it was actually stemming from the Western states in their fear of losing control of the development of customary law when we moved from having about 60 states towards 200. And having followed the debates at the UN, at the Sixth Committee, I think it's really quite fascinating how the notion of persistent objectors is treated by the states. For example, I think that what Cyprus said some years ago, they noted that the doctrine dynamites the essence of customary international law. And that really is something I think opens up a whole new discussion there. How does it do that? And is it something we want to preserve? Is this a good thing or a bad thing? Or is it something we need to rethink how persistent objectors could, is there such a thing? Or is it something else in fact? And if it is it worth preserving? Now to this related point, and I think I will leave most of this for Jean, because I know in his book he deals quite a bit with the Twale critics towards custom, and especially engages with Chimney's article in the American Journal. But I do think it's interesting, as you noted, Omri, how this discussion just has died out, apart from these few voices here and there, and how it could be even turned around, like Jean notes that actually Chimney might be doing a disfavor to the developing countries, if I read that correctly, in terms of their engagement and participation in the formation of custom. And I think my final point goes to what Ingrid says. Yeah, I mean, Customary International, it's not a moral tool. Use Kogan's maybe, but Customary International law, I have quite systematically always opposed these arguments that if there are, I don't know, horrendous crimes that go against the conscience of humanity, that therefore the prohibition is customary. No, it's not. We need the practice there. And that one function of Customary International indeed is expectation management. So what you were saying about, rather than being a sort of historic, but I guess forward-looking, I think it's both. We have Customary International that stems from past behavior and belief that it's legally binding, which creates the expectations that other states can rely on, and creates the predictability, which is one of then the key features of the rule of law in international law. But yeah, I leave it at that for now.
I'm about to call on Professor Wirth, but before doing so, I want to just introduce a couple of elements from the chat that people may not have seen. First of all, Professor David Stewart has interjected that he very often interacts with diplomats and that they very often object to customary international law. So in fact, whether those objections have disappeared is open to question. And then the question was raised about use cogains. In other words, I guess this gets perhaps to the issue of legitimacy, which Professor d'Aspremont raised. But Professor Wirth, I think you said quite a few. You spoke of use cogains. You spoke of human rights, and I wondered how you distinguish customary law from general principles of international law accepted by civilized nations, because I just thought your remarks sort of tended perhaps to ally the two. Maybe I'm misunderstanding you, but I just throw that out as a provocative remark coming out of the questions, and then see if you have any reactions.
That's a lot, but so no, all good. This is fascinating. So on acquiescence, Omri, you said, well, we kind of have to use it, and I'm not opposed to using it. I think one of the beauties of custom is the way that it can become a universal norm without the transaction costs of negotiating a treaty, and I think one of the appeals of custom is it really does aspire to be universal. Yes, you can have persistent objectors, but there really aren't very many. I mean, when we talk about custom, we're generally talking about norms that are quite universal. My point on acquiescence was it's just I think practically very hard to square acquiescence with a strongly consent-based view. And obviously you can try, and many people do try, and I understand those arguments, but I honestly think small states, there are a vast number of customary international legal norms and obligations ranging from an incredible number of topics. And it's just a legal fiction in a sense to say that acquiescence is the same as kind of formal consent. I think that's okay, but I think it shades custom into looking like something a little bit different. It's universal, it's based on acquiescence, and I think it's possible to analogize that to constitutions. And I do think it then impacts how we think about consent elsewhere in customary international law. So that was you. Nora, you said it's not, we shouldn't have this moral element to custom. I guess it shouldn't be aspirational in a sense. I think that's a very rationally coherent position as a positivist, and I think that makes sense. I will challenge you to walk into a room of people and argue that there is no customary international law norm against torture because a lot of countries torture. Yeah, I'm serious. Like you sure. I'm just not. I just don't think that's where most people are when they took. So I do actually think some parts of custom are somewhat aspirational. Maybe they shouldn't be. Again, I tend to think this is something. Maybe it's good about custom. Maybe it's not. Maybe we have such a thin system. We should just do the very things that everyone actually consents to. We should get rid of acquiescence. We should get rid of any moral component. We should just look at what states do and do enough states do it. And then we generate some practice. I'm not sure what we have left, and I'm not sure if it has the same value, but maybe it does. No, I don't think that custom and general practices are the same. And in fact, because I just said that I think that maybe with custom, what we're really interested is just opinio juris and not so much state practice. If anything, I kind of see my remarks as headed in the other direction. But Jean, no doubt, has a lot to say.
Jean, do you have a lot to say?
We all have a lot to say. No, I'll just have a few quick points, because actually I do believe we agree with one another more than we think. Maybe to the great dismay of the audience. No, maybe I'll start with a point on persistent objector, which has finally reached the table. I mean, and in that respect, I can't help highlighting that the persistent objector doctrine was an invention of the West to protect itself against the new majority at the United Nations General Assembly. And interestingly now, the discourse has changed very much, and we sell it as a tool for to defend the periphery. So it's very interesting that we sell the doctrine of the persistent objector very differently today. It was at the beginning the West trying to defend its own interest against the new majorities in the wake of decolonization. And now we sell it as a way to say, you see, custom can accommodate minorities, it can accommodate the periphery, it can accommodate the non-West. And so that's fine, but just let's acknowledge we've changed the discourse. And it's also fine that there is a process of reappropriation of the doctrine of persistent objector by the periphery. And that's for the best. So I'm not saying we need to stick to the genealogy of the doctrine. That being said, so possibly the doctrine of persistent objective has been reappropriated by those states that feel at the periphery. But that brings us in another question that has been raised tonight, which is this question of inequality. Inequality between states. And it seems that in the chat, many people in their daily business encounter that question of inequality. I must say that when it comes to custom international law, the question of inequality doesn't sound to me a conceptual issue. I don't think there's a structural inequality in the doctrine. I think that the inequality is just a very it's nuts and bolts. It's a matter of means of communication and human resources. Take an example: state practice. What it takes is to have a lot of means to publicize your state practice, just as Germany now does with a new website just to publicize and spread German practice on international law. Or it takes a huge team to respond to the comments of the LC. It takes a huge team to follow the practice of others. And it also takes a huge team to use and take advantage of the doctrine of persistent objector. And so that's why actually I have some doubts as to whether the doctrine of persistent objector can perform this function of protecting minorities, because it takes a lot of means to be able to follow what's going on there and then suddenly raise your objection. So I think the question of inequality is first and foremost a very, very practical question of human resources. So that was my second one. A very quick point on the idea of constitution, which was put forward by Ingrid, and it's great food for thought, and to surprisingly to a large extent, I like it. I like the idea and the analogy of the constitution for one reason, which is that it is a nice way to answer a big question, which is what is the foundation of custom? Because constitutions, one feature of constitutions in terms of foundation is that they are self-referential. What is the foundation of a constitution? Constituted by the constitution. The constitution is the constitution because it constitutes the people of the nation, and the signature of the people at the end of the constitution constitutes the signing party, the people. So, and it's the same with custom. I think the analogy with the constitution is very helpful, because most of the time people will say the foundation of custom is custom. So I think by using the analogy of the constitution, you acknowledge the very fundamental self-referential character of custom. Finally, acquiescence. And in that respect, I mean, I share Ingrid's reservations, and I was surprised that Omri was so sympathetic to the idea of acquiescence, because I think acquiescence is a very, I mean, accommodating and coming to terms with acquiescence as something instrumental in the formation of custom is actually a strong denial of the current modern understanding of custom. Custom is based on the idea of self-production, self-creation. The addressees of the norm will contribute to the formation of the norm. And this is the traditional modern idea of creation of norms. And I think if you go on into acquiescence, you actually carry out a conceptual revolution, which is entirely fine with me. I mean, I'm not wedded to any understanding of custom, but it's just, I think it's not a benign debate. If you accommodate, if you say acquiescence plays a role, I think you're really revamping our understanding of custom. That's better. It will give us another 50 years of work on the matter. That's fine, but I do think it's certainly not.
So now a lot is on the table. I guess that last remark probably calls for a response from Omri, but I also just want to remind everyone we have a question from the audience about use cogains, and I want someone to address it if anyone is willing to tackle that. But first I'll give you, so the question being, is use cogains custom? Is it a very strong form of custom? How does it relate to custom? But before we get to that, Omri, we were talking about acquiescence. I think as I understood it, the remark from Jean was, if you accept acquiescence, everything you said before is gone. So anyway, what do you think?
I mean, it was totally worth showing up tonight just to be called a revolutionary theoretician or whatnot. But I think it's really, not so much a revolution in the sense that any custom in any society as a legal tool, I mean, was usually something that was carried forward by a great majority, silent majority, right? I mean, some actors did certain things that other actors had noted was going on and went along with it. And I think in many ways, this is the same way in customary international law. And when we look for a general practice, and this goes to one of the comments we had here about people saying, it's never a lot of states or whatever. It doesn't have to be many states. It has to be sufficiently widespread and representative. Okay, so there's the whole idea about customary international law being born out of 1, 2, 3 instances of practice, or 2, 3, 4 states only. I mean, and it has some credibility when you look into it, precisely because acceptance is so big. And there has to be some practice because it is custom, it's material. It's not just something in the air, but it doesn't have to be something that all states follow or all states explicitly or expressly accept. So I think if that sounds wild, the only thing I'll say is that the theory itself has so many safety valves and so much flexibility to accommodate the different interests of states, those that want to rule, those that don't want to rule. Indeed, they need to make themselves heard, and there are practical problems, just as Jean told us. But this is, I think, coherent overall. And I'll just add one other thing about Jean's comment about the secondary rules, primary rules issue. At least with respect to customary international law, I think we know that the meta rules, or the Germans love calling it that, I think they are customary rules, because I think there's so much practice by any state official in foreign ministries, by domestic judges, by the parliaments, that when they look for a rule of customary international law, they say we are bound to look for a general practice accepted as law. They're not bound to do that by the Constitution. They're bound to do that by international law. They accept it. And the ILC exercise was very useful in showing us that. So I think if there's any kind of secondary primary rule thing there where we can really be on the safe side, it's with custom. With use cogents, just to say one sentence, sounds very complicated. I always think of it as a very simple thing. It's a rule that has a tag attached to it that says you can't violate it under any circumstances. So it's usually a rule of customary international law. If all states in the world got around and say, let's write a treaty and say there can be no reservations, this is a rule of use cogents, it would also be a rule of use cogents. That's the way I view it, and I think it fits the definition in the Vienna Convention. That's what I would say.
So we are definitely around our table, and I think we've reached the point in the conversation where I'm going to stop using honorifics because I think it's just quicker. So I'm calling on Nora.
Thank you. Thank you very much. I'm very happy to echo what Omri said about use cogents. I see that as something that is separate, even if oftentimes linked to customary international law. So I don't think it's something that should be conceptualized as the customary international law plus or something like that. It's use cogents, as I said before, can and most of the time does contain very strong moral undertones. Customary international law, not necessarily. Going back to what was said about the equality between states and equality of states in the formation of custom, I think it's something maybe to take note of the states that are affected or specially affected. And I found this really interesting when I was recently reading again the article by Kevin John Heller, where he proposes this new idea of specially affected states as having this this additional weight in determining when a custom is being formed, and if that can lead into more equality in custom formation. So that's, I guess, a way to try and move away from pure power politics towards taking into account those who are engaging, but also those who are affected. And this goes beyond, I guess, this traditional thinking that, say, only coastal states can play part in the delimitation issues, for example. It may not be always so simple. But additionally, in making customary international law more equal or more inclusive, of course, then a key point is that the ICJ is taking into account practice and opinion really globally, not just the powerful states or Western states. And at the same time, I think this leads to the issue we haven't really discussed yet, which is the legitimacy or the role of, for example, UN General Assembly resolutions as evidence of customary international law. So is customary international law really still state-centric, or should we bring in non-state actors, and to what extent? But yeah, I think I was opening up too many wormholes there, but I'll stop.
Ingrid.
So gosh, there's so many things. So let me just maybe use cogents, right? Because I think I understand both Omri and Nora as saying, hey, like what's so special? Use cogents is just like a treaty from which we say you can't make any reservations to this, and it's like universal. Was that, but you can exit a treaty. You can't exit custom. Like, I just think that's a fascinating part of custom, and it makes it kind of like, it is like a constitution. And it helps understand the entrenchment. Like, you can try to exit custom, some of the custom by sort of, I don't know, overthrowing the system or withdrawing your consent, but it doesn't work the same as treaties. If you have and again, I don't really have an agenda that's like good or bad, but it binds you in a way that I don't think treaty commitments do. It's supposed to be universal. And once you're in the system, it's really hard. I mean, you can choose not to be a state, right? But once you join the community of states, you don't have a lot of power to say, I'd like to be a state, but I don't want to be bound by any of these parts of your custom. But you can completely do that with treaties. So just a thought. And I just wanted to say how much I'm learning from this conversation and enjoying it.
Jean.
Just like Ingrid said, I'm enjoying this tremendously. So thank you all, and thank you again, Tim, for setting this up. I have 3 points: one orthodox point, one cynical point, and one very pragmatic point. The orthodox point, and so let me for once not be the heretic, use cogents question. Well, I mean, use cogents is not a matter of source. Use cogents is a matter of hierarchy of norms. Use cogents is not a different degree of bindingness. So I think when we discuss custom, we raise a question of sources and law identification. I don't think use cogents has anything to do with sources. It's a limitation to the freedom to contract. There are certain things you cannot contract out, and there is a small aggravated regime of responsibility in the Article on State Responsibility, Article 40 and 41. I don't think custom has anything to do with this. But that's me playing the orthodox guy for once. So let me just say, I don't understand the debate on use cogents here. The cynical point now. The cynical point brings me back to Omri's claim that the criteria on custom international law are custom. Well, we may disagree slightly on this, because I still believe that the practice that is out there, and there's a lot of practice, is an argumentative practice. It's not a behavioral practice. I don't think we have state practice, so to speak. We have argumentative. They argue that they identify custom this way. But I don't think you can have actual state behavior on the identification of custom. But anyway, let's leave this aside. And it's nice of bit of disagreement tonight. My point is actually, and that's why it's cynical, I don't think we can make any other argument than custom is custom. I don't think any other argument is possible, because that's a move of closure. If we cannot say the criteria of custom international law are custom, I think we're screwed and we leave international law foundationless. And of course, as modern creators, we cannot do this. We want everything having foundations within international law. We want internal foundation. We want a self-referential system. So we're stuck with that argument. That's the only argument we can make. The criteria of custom international are custom. And if we cannot uphold that argument, we have a serious problem. So that was the cynical remark. The last one is a pragmatic point. On this question brought by Nora, there's been a very stellar article apart. I must say this whole debate on specially affected states, it sounds very much like a storm in a cup of tea. And for once, I will side with the court. I think the court took a very pragmatic position. You do not have a continental shelf. You don't produce practice pertaining to the continental shelf. You do not have nuclear military technology. You don't produce any practice regarding the use of nuclear weapon. I mean, I really don't see the problem here. The wording was certainly very clumsy. And we in 1969, in the midst of decolonization, it feels like you're discriminating between states. And of course, in the 21st century, it sounds even more awkward. But I think I think the court was just clumsy in its wording. But the gist of the position, which is you don't have a continental shelf, you don't have practice, doesn't seem controversial to me.
So we're getting actually to the crescendo of this gathering, and there isn't that much time left. Jean has introduced a couple of things that I actually wanted to come back to anyway, because really I think foundations and legitimacy. And at the very beginning, Jean said, look, legitimacy is something that comes from the outside looking in. If you're within international law, you're not talking about legitimacy, but you're only looking when you're looking from the outside. Of course, international law wants to be legitimate, has to be legitimate. So it affects it in that sense, but it's an external measure that says whether it's legitimate or not. I think that was Jean's point. But I want you to address that internal measure. I had a conversation, I think John Bolton, you've all heard of him, a great lover of international law, and he said that he thought customary international law was a snake through whose head we should drive a nail. So that was an expression of, not thinking that it was legitimate by some kind of external standard. So in response to that point of view, I think it's useful or would be useful to hear you, who are such prominent experts on customary law, to express why, by some kind of external set standard, it is in fact worthwhile. And in doing so, you probably will have to articulate a couple of fundamental principles, but we'll see what happens. I think we have a time really to go around once more with each of our four panelists and fairly quickly react, particularly perhaps on this legitimacy point. Omri.
Thanks. There's so much that's been said that we'll have to arrange another time to meet all of us properly face to face and go on a weekend getaway or something and enjoy all of these points. But I think on legitimacy, I mean, the most important thing to grapple with is, and this goes to questions of philosophy of law that are greater than all we've discussed today. It's a two-edged sword. It's a dangerous concept. I mean, law and legitimacy, law has to be legitimate. But of course, what is legitimate is a big argument, as opposed to what is the law. That should be a much smaller, more confined argument. I mean, look at immunities. There's a big fight going on as we speak in the world. Impunity or not, or immunity, right? And those who, want to fight immunity say, impunity is bad, and they're right. And let's stop crimes and make people pay for them. But they seem to forget that immunity is in place to prevent international friction and to make sure that, we kind of enable diplomatic relations and international intercourse. So what is more legitimate, right? So I think it's important to distinguish the question of legitimacy from what the law is. And I agree that it is both internal and external to the law. I mean, we as lawyers need to ask, is this legitimate? Should we change it? Should we go with it? Should we approve of it? But it does also introduce a measure of subjectivity that we have to reckon with. So that's my point.
Nora?
Thank you. I would say that customary international law is really the only source that reflects reality. It bridges legal aspirations and even legal fiction with what's actually happening, bringing this sociological element into the law. It shows the social practice, how it is accepted by others, how others respond to a certain practice. And I think that is really where the strongest claim for its legitimacy as one of the main sources of international law lies.
Jean?
Well, I might just maybe expand slightly on what I said earlier about the idea of legitimacy, and I think that's in that respect I would concur with what Omri and Nora said, which is that, albeit important, the debate on legitimacy is stifled and repressed by international law. International law does not allow that debate to be carried out in its own terms. International law would only allow the debate in terms of law identification, of bindingness, and so on. And that's nothing surprising. If law or international law allows the question of legitimacy to be raised, it already means it's already an acknowledgement that international law is not legitimate. So that's why the question is not even allowed within the discourse. And if international law were to do differently, it would make itself dependent on something else than itself. Whereas international law as a modern discourse is self-referential, self-explanatory, and must explain itself. Otherwise, it's vulnerable to other things. I think the key question is whether international law is successful in keeping the question of legitimacy at bay. That's a question. I think he tries to do so, but it is not entirely clear. And Tim, I think that's what you alluded to. I think he tries to chase out the question of legitimacy, but maybe the question of legitimacy is everywhere, which would mean that the closure of international law.
Ingrid.
The reason that custom struggles with legitimacy is analogous to the reason that domestic constitutions struggle with legitimacy. Custom is a way of taking certain norms, certain concepts outside of the regular political process, entrenching them in a certain way, deriving them in ways that aren't completely based on consent. Constitutions do exactly the same thing. They take some things off the political table. They say you have your normal process of legislation, but in the background, we have these things, and these things are super hard to change. And they're super hard to change because they're foundational to who we are and what we do. That makes them less legitimate by the measures that we would use, for example, to evaluate whether an act of parliament is legitimate, right? We're using a different set of tools to decide whether entrenched norms and constitutional systems are legitimate or not. And they always struggle with legitimacy. My constitution was, I mean, we all know, my God, look at it. Like, how is that thing possibly legitimate? Like, how can I possibly be forced to live under my own constitution, right? But we accept it as having different rules of legitimacy because that's what we need to do to join in the society together. And I think there are some strong analogies to international law. Maybe we should tear it all down. I get that. Maybe that's the right answer in my country too. Maybe we tear it all down and start over with something that has better origins and is juster from the beginning. But these questions of legitimacy, I think, will persist, and a robust legal system needs a method of entrenchment and a beginning place. And that's what custom is for us.
I think that's a particularly rousing and inspiring set of remarks on which to conclude. The customary, it makes our field seem very important to end in that way. I think we have had gathered here for this session an incredibly impressive group of experts. And I was just fascinated to hear you talking to each other, and I think our whole audience was fascinated to hear you talking to each other. Before giving you your much deserved applause, I do want to mention that the committee of the ABILA on the legitimacy and fundamental principles of international law has some kind of a social gathering immediately following this meeting, which you have to enter by pressing some different button. So if you're interested in participating in that social gathering, everyone who's watching is invited. But much more important than that is the immediate joy that we have in having heard such wonderful remarks from such wonderful scholars. And I hope everyone will join me. You can't see them, so you can only see me wildly applauding with incredible enthusiasm these wonderful remarks. Thank you very much.